Well, when I screw up, I try hard to take accountability for a screw up. And I have to take accountability for one here. I did an incomplete job of going into the weeds on the birthright citizenship issue. So let's discuss that. Hey there, Tony DeWitt here. I'm a retired Missouri attorney now living my best life on a beach in Florida, but I do not dispense legal advice by video. With that understanding out of the way, here's what we're discussing today. Now, my way of attacking any problem is to go into what I call my best authority mode. I look at a problem as if I was responsible for solving it. So, if I was representing an illegal alien on the birthright citizenship issue, that was how I took on this particular problem. Well, one of the real benefits of being in a law office with other lawyers is you get a lot of what if questions. You'll draft something, you'll send it on for review, somebody will come back and sit down at your desk and say, I don't think I provided you with this fact. So I'm just going to tell you that this thing happened. And how does that impact your analysis? And of course, it would often change it. And so the more you talk with other people in a law office, the better ideas get, and you shoehorn those arguments into your analysis. And pretty soon you come up with a product that will more than likely than not carry the day. So I would often go back to the issue and work up a defense on the basis of the issues that were raised. It is valuable to have other people criticize your work. Some of the least effective lawyers in handling cases are the ones who never get feedback and never seek it. And there is often a presumption among lawyers, and okay, I'm no different, that their particular brand of feces is odor free. Spoiler alert, that's wrong. So, in analyzing the birthright citizenship issue here, I ignored a significant part of the problem. The rules of construction say that every word in a sentence, every phrase in a passage must be given its full intendment. And as we mentioned the other day, it has to be interpreted in the context of the way the language was used at the time. In analyzing the issue of birthright citizenship, I overlooked a very important part of the phrase of the 14th Amendment, and that was subject to the jurisdiction of the United States. Now, I have an explanation for that. It's not an excuse, it's an explanation for why I thought about it this way. I now realize I missed this. Normally, when lawyers refer to jurisdiction, we think about the authority of the court to issue a binding judgment in a case. Does the court have jurisdiction over the person, and does it have jurisdiction over the subject matter? If it does, then it can issue a binding judgment. But with respect to the 14th Amendment, that oversimplifies the issue. The phrase in the citizenship provision, subject to the jurisdiction of the United States, in 1868, as used in the 14th Amendment, specifically in its citizenship clause, referred to being legally subject to the authority and laws of the United States. At the time, this phrase was intended to clarify which individuals born in the U.S. would be granted citizenship. Now, key aspects of the 1868 meaning include, first, the exclusion of certain groups. It excluded foreign diplomats and their children who were not subject to the U.S. jurisdiction due to diplomatic immunity. That makes sense because a Russian diplomat staying at his embassy, it is considered to be Russian soil. A host country can violate the national sovereignty of another country if it invades its embassy property. So that's one of those things that, generally speaking, with the exception of Iran, countries do not do. So when Boris and Natasha have a little Tatiana at Georgetown Hospital in D.C., not only do they have diplomatic immunity, so does their child. And as such, they're not subject to the jurisdiction of the United States, and little Tatiana can't be an American citizen. The phrase also excluded members of the sovereign Native American tribes, as they were considered members of separate political communities not fully under the U.S. jurisdiction. That was because their system of government involved a chief, and it also involved things like tribal courts. So again, they had a separate form of government. They were not considered at the time of the 1868 application of the 14th Amendment to be covered by that amendment. Interestingly enough, inspired by the high rate of Native American enlistment during World War I, President Calvin Coolidge signed the Indian Citizenship Act. And as such, American Indians, or Native Americans, the first people of this country, were the last to receive citizenship. It really isn't funny, it's just kind of sad. The phrase also excluded individuals born to occupying foreign forces, but keep in mind there were no occupying foreign forces in 1868. And at the time, there was also no such thing as an illegal alien. So that talks about who it excluded. Who did it include? Well, it included those born in the U.S. who were not under the authority of a foreign sovereign, such as most free persons and formerly enslaved individuals. For example, somebody who was brought here in 1820 and had a child in 1825, that child born in 1825 by 1868 was of legal age, and that child very clearly had citizenship under the 14th Amendment because he was somebody who was under the protection of the United States law. This was particularly significant for granting citizenship to formerly enslaved people following the Civil War, as it ensured their legal equality under United States law. Okay, that's a legal fiction. It made it possible for them to struggle for the next 100 years to actually achieve something like equality through Congress and the courts. Importantly, the term jurisdiction at the time was understood in a more comprehensive sense, meaning the full legal allegiance to the United States as opposed to partial or limited jurisdiction. For example, foreign nationals who come here are subject to U.S. criminal laws. If they speed, they can get a ticket. If they drive drunk, they can be arrested for DUI. But they still owe their allegiance to their home nation. This is an important distinction because if they still owed allegiance to a foreign power, they were not fully allegiant to the United States. This interpretation was clarified, which in this case means glossed over, in the 1866 Civil Rights Act, which served as a precursor to the 14th Amendment. It was later confirmed in Supreme Court rulings, one of the most important being United States versus Wong Kim Ark, an 1898 case. That case is often said to have upheld birthright citizenship under the 14th Amendment. But it probably is not on all fours with the situation that we're discussing now. And so it may not be as close to being on point as many people believe. Now, a lot of people cite this case as if it was a done deal and there's no further analysis. Indeed, without citing this case, I approach that problem the same way, relying on half of the plain language. Yet the term illegal alien wasn't a part of the lexicon during the 1860s. The term illegal alien first appeared in U.S. federal law with the enactment of the Immigration and Nationality Act of 1952, also known as the McCarran-Walter Act. This comprehensive immigration statute codified existing immigration laws and established terminology including alien and illegal alien. Let's look at the historical context here. The term alien, meaning a non-citizen, was used as early as the Naturalization Act of 1790. However, early laws did not use the modifier illegal because immigration was relatively unrestricted until the late 19th and early 20th centuries. If you wanted to be an American, you got on a boat, you sailed to our shores, you jumped off the boat, kissed the ground, and while you might have been an alien, you could still apply for citizenship, usually without any problem at all. But sometimes people who got here before you did made it really difficult for you if you came later. The Chinese Exclusion Act of 1882 and subsequent acts began restricting immigration based on nationality, and they imposed penalties for unauthorized entry, all without calling the aliens illegal. The Immigration Act of 1924 further restricted immigration and set up a quota system, but did not use the specific term illegal alien. The Immigration and Nationality Act of 1952 explicitly used that term, illegal alien, to describe individuals in the United States without legal authorization. This term distinguished unauthorized immigrants from those who were legally admitted under the law. For example, people who came subject to the provisions of the INA, who met the requirements for citizenship, were deemed to be lawful resident aliens. If you watched television in the 1960s, you often saw ads interspersed between Popeye and Beanie and Cecil for the government that reminded resident aliens of the need to register with the U.S. government and the penalties that came with it if they did not. So, because there was now this status of illegal alien, that throws some light on the Kim Ark case, such that it may not be the best historical understanding of the 14th Amendment. In Wong Kim, the parents of the child born in the United States were lawful resident aliens. They owned property here. They had a business here, even though they were Chinese citizens. They got here before the Chinese Exclusion Acts. Then they went home. They left their son here. When he went back to China to go visit them and returned, they wouldn't let him into the country because of the Alien Exclusion or the Chinese Exclusion Acts. The court held that their lawful residence made them subject to the jurisdiction of the United States. But again, the difference was nothing said that they were illegal aliens when they had this child. They were lawful resident aliens when they had the child. It says so in the opinion. And perhaps more importantly, the issue of comprehensive jurisdiction, that issue of being subject to the protection and to the allegiance of the foreign state, is something that frequently raises its head even today in criminal prosecutions. When foreign nationals from most countries are arrested or detained, they may, upon request, have their consular officers notified without delay of their arrest or detention, and may have their communications to their consular officers forwarded without delay. In addition, foreign nationals must be advised of this information without delay. So, in addition to you have the right to remain silent, should you give up the right to remain silent, everything you say will be taken against you. They also have to be told, oh, by the way, you're a citizen from Mexico and you have a right to contact your consular office for help. For foreign nationals of some countries, consular officers must be notified of the arrest or detention of a foreign national, even if the foreign national does not request or does not want the notification. Consular officers are entitled to communicate with and to have access to their nationals in detention and to provide consular assistance to them, including arranging for legal representation. In other words, even though arrested or detained in the United States, they are still subject to the protection of their home country, and hence they're not subject to the jurisdiction of the United States, nor do they owe allegiance to the United States. So there is an argument that is historically supported and grounded in the text of the Constitution that supports the Trump executive order on birthright citizenship. The argument goes something like this. At the time of the 14th Amendment, there was only one class of alien. If someone was here from another country, they were an alien. Because there was no immigration restrictions at the time, they could adopt the United States as their country, reject the citizenship of their home country, and become a naturalized citizen. And keep in mind, a lawful resident alien applying for citizenship in this country must renounce the citizenship of their home country. But before the limitations on immigration, there was no such thing as an illegal alien. Then Congress, exercising the will of the people, started creating these new classes of aliens, starting with the Chinese Exclusion Acts. Those individuals, because they owed allegiance to the Emperor of China, were not subject to admission or naturalization. Going back to historical underpinnings, as the law changed, the class of aliens was changed again to those here legally, resident aliens, and those here unlawfully, illegal aliens. Because they had not come legally, those aliens were still subject to the jurisdiction of their home country and had the right to full consular access, much like John McCain, who was born in Panama but was still a U.S. citizen because he was subject to the jurisdiction of his home country. Now, will this argument prevail at the Supreme Court? I have no idea. It's anyone's guess, but I would guess that if it was well made, it could certainly be persuasive. And you don't have to agree with me, but I think there is some power in the argument that you can't come here as the citizen of another country with the intent to remain here illegally and produce children who would be citizens for the specific purpose of sponsoring the whole family once they attained legal age. That would seem to be a workaround, so to speak, of the Immigration and Nationalization Act based on this very narrow reading of the 14th Amendment. Now, it's going to go to the United States Supreme Court. It's going to be a very complicated case, and a lot of experts are going to come on Fox News and say that the executive order is golden. It's going to be sustained by the court. No worries. These other judges were just completely wrong. And then there'll be a lot of people who go on MSNBC and say that the EO is post-digested nutrition and it stinks to high heaven. We're going to get all kinds of opinions about that. But that's the wonderful thing about this country. We have freedom of expression. We get to express our opinions. We get to say what we think. But keep in mind that while the opinion of those experts on TV might very well be supported by years of study, prestigious law degrees from prestigious institutions, and decades of government service, their opinion is no more well-founded than yours, because neither you nor they get to make the final call. That will be 4 women and 5 men on the Supreme Court, and that's at least 1 full year away. During that time, a lot of things could change, so we'll have to stay tuned. That's what I have for you today. Again, sorry I booted that. I should have done a more objective view of this, but as you can see, it took some time to get there, and the original video would have been 50 minutes long if I'd done that. So thank you for putting up with that. Thanks for watching my video. If you have a request for me to cover a topic, please send me an email to the address above, and in the subject line put video request. If you have comments, drop them in the comments down below. If you found the content worthy, please consider subscribing. Since I started doing this work, I have always asked listeners to consider doing just one kind thing every day to make somebody else smile or make their life better in some way. Please consider doing that. It makes the world a better place. Now, YouTube has some suggestions for other videos of mine you may find interesting.